We are discussing a recent adjudication order passed by ROC. This is dated 12th February 2026, very recent order. This case is extremely important because it clearly explains the difference between penalty and fine regime, the impact of decriminalization of offences, why Section 454 adjudication was rejected in this case, and when compounding under Section 441 becomes the only remedy. So the default here in this case is 2013-14. If you see, the case belongs to Suyash Commercials Limited. Here, company failed to file financial statements within the statutory period under Section 137, subsection 1. So, as a result, proceedings were initiated for violation of Section 137, subsection 3 of Companies Act 2013. You see here, the officers in default identified as 3 officers in default, names are given here. This is in line with Section 137, subsection 3, which fixes the liability of managing director, CFO, or in their absence, all the directors. This is what the provision says. So, what Section 137 requires is financial statement must be filed with a ROC within 30 days of AGM. This is what Section 137 says. Consequences of default on the company 10,000 plus 100 rupees per day. So maximum it will go up to 2 lakh. And on directors, 10,000 is a base plus 100 rupees per day, maximum 50,000 per director. This provision is civil in nature today, but it was criminal earlier. So this default occurred for the financial year 2013-14. In this period, for 13-14, so show cause notice issued, prosecution filed, and company also filed belated filing in 2017 itself. So there was a delay of 1028 days is a delay. 1028 days is a delay for filing of financials. So it filed very late. So then somehow this default was rectified by filing adjudication notice 18th December 2025. So this order passed in February 12th 2026. Company also submitted to ROC that the default was already rectified. Financials were filed with additional fees. So rectification was done before adjudication notice. And company requested for nil penalty under section 454 subsection 3. Company requested under section 454. So if you see, the crucial legal turning point is decriminalization. ROC examined whether section 454 adjudication can apply. The key finding is the offense related to financial year 2013 and 14. So this is a period is 13-14. This period is prior to 2/11/2018. So hence it falls under the old fine regime. So old fine regime. That period it was criminalization was the criminal penalty, criminal liability. So hence it falls under old fine regime, not under penalty regime those days. So this is the most important learning here from this case. Why adjudication under section 454 was rejected? ROC held that section 454 applies only to the penalty-based defaults. This default attracted fine and prosecution. So adjudication order cannot be passed. So adjudication application was disposed without imposing any penalty. If you see the order, all are 0 penalty, no penalty levy. Now what is the remedy? Section 441 compounding application. ROC clearly stated company and directors are at liberty to apply for compounding under section 441 before RD or NCLT as applicable. So this guidance is extremely valuable for company and professionals. This is the very, very important. So date of default is a critical. Decriminalization is not retrospective. Section 454 is not the universal remedy for all issues. Because old defaults, then now compounding only. Hope you are clear. Thank you. So the conclusion is proper statutory interpretation is required, and we have to see what are the limits of ROC adjudication powers, and we also see the importance of historical legal framework. So always check the year of default, distinguish between penalty regime and fine regime, so which avoid filing wrong applications and save time and cost by choosing the correct remedy. Thank you.